Counsel for the petitioner, you may proceed.
Thank you, Your Honor. May it please the court, I'm Shay Moxon of Brandon, Humphreys and Berman, and I represent the petitioner, CCM Condominium Association. Today, we're asking the court to restore the proposal for judgment statute to its plain meaning and to correct some statements and earlier opinions that have been turned into a judicial rewriting of the statute. The issue in this case is whether CCM recovered enough to be entitled to attorney's fees under its proposal for settlement. And that turns on the statutory definition of judgment obtained and whether it includes post-offer prejudgment interest or post-offer costs. Here, including either of those amounts would entitle CCM to its fees. And the Fourth District concluded that under the plain meaning of the statute, CCM would be entitled to its fees, but it felt constrained by those earlier decisions, White v. Steak and Ale and Chance v. Mercury, to exclude those post-offer amounts. And I'll address why those cases didn't actually hold that. But first, I would like to go over what the statute actually says, because that is the starting point for any statutory interpretation question. Subsection 6 of 768.79 sets out a clear definition of judgment obtained. It says the term judgment obtained means the amount of the net judgment entered plus, and then certain amounts that don't apply in this case. And so there are two key takeaways from that. First, the starting point for the calculation is the net judgment entered.
Counsel, can I pause you right there? Net of what?
It would be net of set-offs, for example, set-offs or collateral sources, or settlements with other defendants, net of comparative fault when that applies. In cases where there's a counterclaim, sometimes each side recovers a verdict and they're set off against each other. And so I believe that the legislature is pointing, including that sentence net, I think it really just re-emphasizes that this is the actual judgment and not the verdict.
Well, I wonder though, let's say I agree with the examples you've given as considerations for netting from the judgment. Where shall I find them in the statute? Right? If your point is that White v. Steak and Ale and its progeny are departures from the statute and we must restore the statute to its meaning, I wonder whether, or maybe I should get your position on whether the word net introduces an ambiguity into the statute or whether it does not.
It does not, Your Honor. There are statutes that provide for set-offs. And so that's part of the background. And then in 768.79 itself, when I said that certain things are sometimes added back to the net judgment entered, those are things that are typically set off against the verdict after trial.
But counsel, the statute already accounts for that. I mean, I think the problem with, I think what I had a similar thought to Justice Coriel. I don't know what the right answer is, but it seems like, part of the appeal of your argument is that we're supposed to, look at the judgment entered, which is just the number on the page, plus these other things that the statute says to add back in. But once you introduce the word net judgment entered, then it arguably, it's either a completely useless word or it's doing some work, and it doesn't seem like your position really accounts for what that work might be doing. And I don't know that there's a clear answer to it, but I think that's the challenge, that's the problem that we're having.
Well, there is no basis anywhere in the statutory definition to conclude that net means that there's you draw some distinction between pre-offer and post-offer amounts of the elements that go into the judgment, such as costs and prejudgment interest. And I can address why those things are included in the judgment. That's one point. There's nothing in the statute that suggests that net is going to be referring to a deduction of costs or prejudgment interest. There's really no basis in the law or the statutes to be deducting those things from the net judgment entered. There are statutes that provide for set-offs of collateral sources and set-offs of statutes. And right in this subsection 6, there's language that says sometimes you add those set-offs back in. And so that's That's an indication for what net means and what it doesn't mean. And also I'd point out that White v. Steak and Ale, Shands v. Mercury, none of those cases, when they started talking about looking at a judgment entered at the time of the offer, and none of that was based on a construction of the word net. So there's really no indication in the statutes or the case law that there's some construction of the word net to decide that what needs to be done is to divide costs and prejudgment interest into pre-offer and post-offer amounts and subtract the post-offer amounts of those elements of the net judgment. So there's no basis in the statute to do that. There are good indications of what the legislature was thinking of when it chose to include the word net in it. And as far as one of the options you suggested, Justice Muniz, I submit that the word net is doing very little work. It's not 100% superfluous, but I think what it's mainly doing is emphasizing that this net judgment entered means the real judgment, the judgment entered at the end of the case. Even the original version of the statute before it had subsection 6, it looked at the judgment entered.
Can I ask you a question? Can I ask you I'm sorry to interrupt. Can I ask you an unrelated question? If we go down the path that you're advocating of, what you're calling the plain meaning approach, how would that play out then in the cases that involve the punitive damages amounts that are where, at the time of the offer, punitive damages weren't even in the case and they appear later, and there's that First DCA case where they say you've got to compare apples to apples, and it seems like it's a similar thing to what this line of cases that's directly relevant here are getting at. If we say that the plain meaning is you compare the offer whenever it was made to the judgment, whatever that is, including the things you wanted to include, how would we then in a later case be able to distinguish that punitive damage situation?
Well, I would point out first that that's not an issue here, but yes, that is something that needs to be considered. The issue that arose in the Palmentary case, it's a very rare instance that arose. And one of the keys in Palmentary was that the proposal in that case was not only served at a time when there were no punitive damages in the case, but the proposal actually disclaimed any claim for punitive damages. And so in Palmentary, the plaintiff served this proposal saying, we are not seeking any punitive damages, so no amount of this proposal is allocated to punitive damages. Also, the statute 768.79, it requires a judgment in the offer to state whether any amount allocated to punitive damages. So that's kind of a very narrow, rare instance where the proposal was served at a time that, it reputed any punitive damages. The whole nature of the case changed after the proposal when punitive damages were added and no new proposal was served. The Palmentary court, another basis for its holding is said this creates an ambiguity. So there are other ways to deal with that issue.
Counsel, why wouldn't, consistent with your reasoning on the prejudgment and post-judgment interest, the situation of punitive damages or any other kind of element of damages that were included in the ultimate net judgment, why shouldn't that number be then compared to what the offer was at the time? Because, the statute is an encouraged settlement, and if somebody doesn't accept the offer, they just run the risk of whatever that judgment may be. And so if consistent with the notion of you got to look at the statutory language, why wouldn't you add punitive damages in there or any other thing like the post-offer, the prejudgment interest?
Well, normally, yes, that's true. The legislature decided when it crafted this statute that the starting point is to look at the net judgment entered at the end of the case. And in the vast majority of cases, there's no question that means all damages. And the damages picture can change over time. For example, in cases where you have, a claim for both past damages and future damages, past and future non-economic or wages lost earning capacity, past and future amounts. The starting point is an end point for those is going to be the date of the verdict. So that picture changes all the time. So just the point that, yes, it's understood, and the way the statute operates, that you look at the damages awarded at the end of the case. And in situations, odd situations like parliamentary, district courts have worked out different ways to deal with that. In parliamentary, with the punitive damage issue, one of the main distinguishing facts is that the proposal disclaimed punitive damages when both the statute and the rule says to state any amount allocated to punitive damages. And in the Segundo case, the one involving the shoulder injury damages, I believe it was the 3rd district, they resolved that by, it never disputed that the plaintiff was entitled to fees. It just held that the only reasonable award of fees under those circumstances was 0.
But let me ask you, the Fourth DCA applied the White case and Precedent, and I understand what they did, and that makes sense to me. But and they were saying we would need to recede from our White decision. And looking at our standards now, like under Poole, where we have to look at to see whether we recede from Precedent or not, we would apply a clearly erroneous rule and then look at reliance. Is there somehow clearly erroneous interpretation of the statute by the court in White?
Well, our first position is that White actually did not set out any holding that requires the exclusion of post-offer amounts.
Let's assume that it did.
If it did, yes, then this could, if this is a actual construction of the statute that's considered a holding, yes, it's in clear conflict with the plain language of the statute. The statutes that defines the judgment obtained as a net judgment entered and doesn't provide any basis to distinguish between pre-offer and post-offer components of the judgment. It looks at the judgment entered at the end of the case and not an imaginary judgment that could have been entered at an earlier point when the offer was served. And
reliance. What about the second half of the question with reliance? I mean, obviously there's a lot of people out there right now who've made settlement offers that are relying on the last 20 years of pretty much uniform interpretation of, or at least whether you call it interpretation of the statute or what courts have kind of assumed the rules of the road to be.
Well, 2 points on that. One is that parties should be entitled to rely on the plain meaning of the statute and what it says. And the statute, the way it's constructed, it sets out a simple comparison of the judgment entered at the end of the case and the amount of the offer. And second, I think it's very unlikely that parties are making any kind of dispositive decisions about amounts of proposals or whether to accept or reject them based on some notion of the exact amount of pre-offer costs or pre-offer prejudgment interest. As a practical matter, parties make their proposals for lump sums and they evaluate them based on the bottom line, what's going to be owed at the end of the case, just like the statute contemplates. In fact, in this case, our proposal was for less than our total amount of damages. So certainly Petri didn't reject it because they thought we were asking for too much in the way of costs in this offer. It had to do with their assessment of damages or liability. The proposal was for $500,000, and our amount of damages, even by the time this offer was served, was at least $549,000. You can find that analysis at page 3609 of the record, just as one illustration. So, parties realistically aren't making proposal for judgment decisions, either the amount or whether to accept based on what they think is the exact amount of the plaintiff's pre-offer costs or pre-offer prejudgment interest at the time, as a practical matter. But additionally, just in the big picture, so this idea that the judgment obtained is cut off at the time the offer is made it has no basis in the statute, and it's, it's this court's duty to apply the law correctly and to correct or clarify its earlier precedents when they get astray from that.
But counsel, I'm sorry to interrupt you, but the parties are definitely making their offers based on what they think is in play at the case at the time that the offers are made. And it seemed like Justice Polston was kind of taking you down a path where if we think that this is a plain meaning case, that, new claims, punitive damages, whatever gets added in later, I mean, clearly that's something that factors in, right?
Yes, and I'd like to point out that these kind of policy decisions, what's the fairest way for the statute to operate? That's ultimately for the legislature to decide. And it made that decision about how to allocate, risks and amounts when it crafted this statute, when it set out this definition of what the judgment obtained means. And also it gave each side a 25% margin of error. The offeree can always be wrong by up to just shy of 25% and avoid the sanction of fees. That's how the legislature decided to deal with, issues of uncertainty, maybe any little questions of imperfections that lawyers could think of along the way. Ultimately, the legislature decided that you compare the offer to the net judgment entered, sometimes with some additional amounts, and everybody can be wrong by right up to 25%. So that's a balance that the legislature struck. And, as the court knows, it's not its prerogative to add from or limit or modify the plain meaning of the statute, because
Counsel,
that's an abrogation. Yes, Your Honor.
Counsel, you are now well into your rebuttal time. You can continue, but you are using rebuttal time.
Well, if there are any questions about our interpretation of the statute, why it includes all costs and all prejudgment interests, or why we maintain that White and Shands did not make any decision about post-offer amounts or whether they should be excluded or included, I'd like to address those. Those are two of our key points. So if there are no questions at this point, I'll save the rest of my time for rebuttal.
Thank you. Counsel?
Good morning. May it please the court. My name is Thomas Hunker with the law firm of Cole, Scott & Cassane, appearing on behalf of the respondent, Petri Pest Control. Overall, the law regarding proposals for settlement has been somewhat obscure, but there is at least one aspect of it that has remained clear and stable throughout the years, and that's the White formula for calculating the 25% threshold for sanctions under Section 768-79. And it's a relatively simple math problem. It's essentially the backbone of how this statute has worked for the past 18 years. It's been relied on in numerous cases. Even the Fourth District, in certifying its question of great public importance, indicated that it's widely used, important tool. We've cited a litany of cases, several cases from this court reaffirming the White formula, many cases from the district courts, federal court, county and circuit courts. This is, for all intents and purposes, the law in Florida, and has been.
The White decision and what they did there the court made sense to me, and how they constructed that. But isn't it different from the statutory language?
Well, the comments that were made by Justice Curiel and Justice Muniz were actually going to be my first point, which is, if you look at how the Fourth District addressed that language, they, in several cases, simply quote the words judgment obtained, leaving out the word net. And I think that's a very important word in the statute, because it's net means after deducting something. And the statute, this is a language that was put into the statute in the 1990 amendments. And this is discussed thoroughly in the briefs in the White case. What does that language mean? The statute doesn't tell us what the word net means.
Well, wouldn't it mean just any net judgment obtained for someone that would be, it's a judgment that's net of any legal deductions that have to be made in order to come to a judgment that should be rendered for someone, like the set off that they specifically meant to add back. There could be like perhaps collateral damages or other things that need to be deducted as a legal matter in order to come down to some net judgment on behalf of someone. Isn't it just a clarification in the statute that it's not some gross amount, it's the net amount that's actually going to be entered as a matter of law for someone seeking it.
Well, that's actually the question that the court grappled with in White is, does net include costs? Because the statute doesn't speak to costs, and costs under the case law that conflicted were not included in a judgment, and certainly not for jurisdictional purposes. It wasn't considered damages, and the statute speaks specifically to damages. And so the court in White looked at the word net and interpreted it, construed it based on how the legislature would have intended it to work.
Well, what does it think in terms of what you add as in the same way as subtracting? If you're going to have costs or attorney fees or prejudgment interest, you add those things. You don't subtract them out. It seems like when you look at the term net, you're looking at deductions, not something you would add.
Deductions, correct. Net is sort of taking the judgment and reducing it to present value as of the date of the offer so that you can compare apples to apples. This is actually the rationale in the conflict case Perez, which the court in White adopted. It's based on how this statute can actually work to promote settlements, to encourage settlements, so that when you're an offeree, and keep in mind, this is a sanctions statute. It's a penalty statute, and it has to be strictly construed in favor of the party against whom the sanctions are supposed to be imposed. So you have to consider the position of the offeree in evaluating the offer, just like the White court did, and what can they be reasonably expected to anticipate. So for example, if in this case, the focus was on prejudgment interest, is the offeree, is it reasonable, fair, common sense? These are the words that were from the White decision and even the Perez decision. Is it reasonable, fair, common sense to impose upon a party the risk of being sanctioned if they are not able to reasonably predict how long the case is going to last for purposes of calculating prejudgment interest from front to back of the case? Or with prejudgment interest, the other problem is that we have a fluctuating interest statute that goes up and down with the variations in the market. And so is it fair to the offeree to have to guess properly as to how the market is going to be throughout the years of litigation and what the interest?
But the problem is we have to apply the statute, not ourselves determine what's fair. Do we not?
Well, it's not. The purpose of the statute is to uphold the law, and words are symbols of meaning. And so the court always looks first to the words in the statute. But if the words don't define themselves, as here, we don't know what net means, it's not defined in the statute, we have to try to determine what the legislature meant, and factors that the court considers.
Counsel, I have a hard time understanding how you get from that word net to your position. I mean, and I understand your policy arguments, but it seems like in terms of an analysis of that language, the only path that leads from the term net to what you're suggesting is a highly motivated path of reasoning. And I'm just struggling to find that in the word net. Could you help me with that? Well,
if the word net is ambiguous, it is not defined in the statute. The CCM hasn't told us what that word means. I mean, at oral argument, they've given some suggestions of what it might include, but we don't know for sure what the legislature.
There's some obvious things that it would mean, like set-offs, right?
Well, actually, if you look at the language of the statute, it has the word plus in between net judgment entered plus, and then it talks about the set-off. So it's almost like the language of the statute is saying these are two different things. You have the net judgment plus the set-offs. So I don't think that's what the legislature could have meant, at least just by the grammatical arrangement of the words of the statute. So it wouldn't be the set-offs. It could be that other things dealing with other claims in the case, but
that's not a comprehensive list of set-offs, as the chief suggested. I mean, any net judgment would be subtracting any set-offs there. There are certainly other type of legally determined set-offs or things that you would subtract in determining to a net judgment. That's not comprehensive, but the statute identifies certain ones that you should add back.
Right. add to the net judgment entered.
Well,
So
yeah,
if you
net judgment obtained. I mean, the obtained part tells you that the math has already been done, right? Judgment obtained means the math has already been done. So the question is, what, if anything, does the word net add to that? And it seems like, you know, I guess some people, you know, there's an argument that it doesn't really add anything. I mean, isn't your burden basically to show that there's enough ambiguity in the statute for the court to say that it's not clearly erroneous, what courts throughout Florida have pretty much uniformly been saying for the last 20 years?
Actually, we aren't the ones asking for the court to recede from its precedent. It's CCM. So
You're talking to a bunch of people who struggle with the idea of, if all of us thought that the text could not bear the meaning that you're asking us to give it, then it probably wouldn't be very much help that you have all this precedent. But if there's enough daylight in the text to where you could, you know, in good conscience think that it could mean what you're saying, then, you know, it kind of shifts the burden, right?
I don't think it shifts the burden, but to justify the precedent, it's the way the statute works is it gives the offeree the ability to make a reasonably accurate determination of what their risk is. If you have to predict every possible change that could possibly happen, amendment of the pleadings to allege other claims or punitive damages, or if you have to predict how long the case is, these things in the future, you're trying to hit a moving target. And also, as in the Amador case, the 5th District pointed out, it gives an incentive to the plaintiff to manipulate the factors by holding off incurring certain costs until after the offer expires, or purposely dragging out the case so that interest continues to accrue. At some point in time, if you're going to sanction a party, they have to have at least some reasonable basis to evaluate what the potential outcomes could be. And I think that's why it has worked for so many years, is that it works. You are able to do this simple math problem, comparing apples to apples on the date the offer was made. And so it's not like asking, as I said, the offeree to do something that is highly speculative. And it doesn't.
Go ahead.
I'm sorry, go ahead.
What's your best argument for, you know, beyond just inaction by the legislature? What's your best argument for there being any indication of an affirmative sort of buy-in from the legislature to what the courts have been saying in terms of how the courts have interpreted this provision?
Well, when the case came up on White, the issue was about costs, and the respondent was arguing that no costs should be considered in the analysis at all. And that had been the holding of several district court decisions that were in conflict with White when it first came up. And the petitioner...
Well, isn't it the case in White that there were no post-offer costs?
That's the factual holding, correct?
So that's the fact they were dealing with. They were not dealing with the issue of post-offer costs, because that simply wasn't an issue in that case.
Sure, but subsequent case law from this court as well.
I'm talking about White.
Yeah, White, sure. But it was almost undisputed that it would only be, and that's why if you read the underlying decision from Perez, and they talk about this being a line of demarcation, to where there's a lot of talk in these decisions about how do we apply this to effectuate the purpose, which is to promote settlement. If you are an offeree and you think you get an offer and it just says one thing, but you have to somehow predict every possible variable of how the case could change in the future, then it breaks down. And also it creates, as I said, and as the Amador case pointed out, these opportunities, these incentives for the plaintiff to unilaterally affect the factors that go into the formula. If you stick with White, you don't have any of those problems. That's why White has lasted this long. The legislature hasn't acted to abrogate it. This court has reaffirmed it in multiple decisions. The federal courts, the lower courts have all applied it. This is actually the first case And even Lewis from the I believe it was the Fifth DCA or the First DCA cited the Fourth District's holding in this case subsequent to it, and didn't quarrel with the holding as prejudgment interest being up to the date the offer was made. So really, this is the only case in 18 years that has ever raised this issue. So, I mean, there is.
Counselor, are you aware of any other place in the Florida statutes where the phrase net judgment exists?
Yes, actually, in the Antunes case that the plaintiff is relying on, or excuse me, the petitioner is relying on, they use that word net judgment entered, but they don't interpret that version of the statute. There was an amendment similar to the one at 1990 to the proposal for settlement statute that similarly defined judgment obtained as net judgment entered. And the way that the court got to its conclusion of including all costs in the judgment is because they didn't deal with that statute. They dealt with the predecessor statute that didn't define, didn't include that net judgment entered language in it. So it's possible, but we don't know, that there would have been a different result. There's also the fact that in Antunes, it was dicta because they didn't preserve when the costs were incurred. Unlike this case, it's undisputed that if the White formula applies, then the Fourth District got it right, because interest costs that would have been awarded on the date the offer was made would not have reached the 25% threshold. So it's a simple math problem. It's fair, it's common sense, it's reasonable, and it's also construing an ambiguity in the statute strictly in favor of the party against whom the sanctions are going to be entered. So it's got to be reasonable. And if you're left with a question of what does this word net mean, then there's no showing of clearly erroneous, that White was clearly erroneous such that this court should depart from its precedent. If anything, all of the evidence of reliance shows that it is correct, and the legislature's inaction is just one element of that. But if you look at the lower court's decisions, the federal court decisions, the fact that this court reaffirmed it multiple times, the duration of it being in place, I mean, if you recede from White, it will tear the backbone out of the statute. And a lot of cases, as the Fourth District pointed out, that have it's widely used statute, it's a very important issue. It will cause a lot of chaos. This is the one area, as I said before, of proposal for settlement law that is pretty settled. And for 18 years until this case came about, there was no real quarrel with the White decision, either from the legislature or from the lower courts or from multiple panels of this court over several decisions between the time it was entered in 2002 and the last statement on it, which was Shands in 2012.
But again, in Shands, the whole issue of the post offer interest, it was about interest there. That's wasn't an issue, and for one reason, it wouldn't have made any difference in whether the fees were going to be awarded or not, because the threshold had already been exceeded. Isn't that correct?
Yes, and the factual holdings, certainly the factual holdings are one thing, but in terms of the formula itself, setting forth the construction of the statute, that has always spoken of prejudgment interest accrued up to the date of the offer, and costs incurred up to the date of the offer, and whatever damages would have been included in a judgment had it been entered on the date the offer was made. That legal holding of White, that formula from White, has been consistently applied by every court since White. In fact, here, the two cases that have been cited as conflict predated White. And there's a reason for that, because White cleared up the law in this area. And the underlying rationale, there's a fairness component to it. I mean, it's not the only factor, but when you're talking about whether a statute should be construed not to create an unreasonable result or an absurd result and should be construed reasonably, this is the rationale of Perez, apples to apples. That's why you compare the amount that was offered to what the judgment would have been had the case concluded on the same day the offer was made. That's apples to apples. If you allow whatever happens over a course of time to be put on the other side of the scale, that creates an apples to oranges comparison, which is like the punitive damage case pointed out. And it wasn't just about, yeah, there was a situation where the offer conflicted, where it said they included punitive damages, but there's multiple decisions in the Segundo line of cases that talk about if it's something that wasn't part of the case at the time the offer was made, you're creating apples to oranges, and it's not a fair comparison. And so that's why the rationale Perez is a reasonable interpretation. It was used by this court in White and subsequently used every time the White formula was applied by this court and subsequent courts.
All right, counsel.
I believe
You've got
that's all
some
I
more
have.
time, but there's no penalty for waiving your time.
I would just ask the court to either approve the Fourth District's decision or discharge the case for lack of jurisdiction.
Thank you.
Thank you.
Rebuttal.
Thank you, Your Honor. First, I'd like to address Mr. Honker's argument that the so-called White formula was a construction of the word net and net judgment entered. That's absolutely incorrect. It is not based on the word net at all. There's absolutely no indication in the White opinion that it was construing the word net. And in fact, the part of the White opinion that created this alleged formula, it wasn't construing the statute at all. It's not even based on a construction of the statute. White essentially goes in two phases. First, there's a part on page 550 that actually looks at the language of the statute and construes what it means. It looks at the definition of judgment obtained, net judgment entered, and it concludes that that includes costs because costs are part of the judgment. If costs weren't going to be included, then the legislature would have said verdict instead of judgment, but because they said judgment, it has to mean something more than damages. And so that's another reason why costs are included. And it rejected the argument that costs are not material for jurisdictional purposes. Those are all reasons to include all costs. And the only costs at issue in that case were pre-offer costs because that was all that was included. So these are all reasons to include this judgment for costs. But where it got away from the statute was when it started talking about these cases, Danis and Scottsdale Insurance, which were decided in the 627-42A context, a completely different statute.
Counsel, I'm sorry to interrupt you because you only have a minute left, but I understand that if you read the White and Shands that, the precise issue that we're talking about now was not in front of the court. And so, you can argue as to whether we applied, the formula, how much weight we should give that. But is it fair to say that sort of the uniform approach in the district courts and in our state has been to try to do this apples to apples comparison, whether you say that it's, was required by our precedents or whatever? I mean, is it fair to say that we would be kind of upending that if we adopt, the reading of the statute that you're advocating?
No, Your Honor, I don't believe that this has become the backbone of proposal for settlement law like Mr. Honker suggested. In many of the cases he's relied on, it's kind of a similar situation where including pre-offer amounts is enough to get to the conclusion you need. And, there are only relatively few cases where it worked the other way, that excluding post-offer amounts made a difference. But that exclusion of post-offer amounts, that was never considered or intended by the White or Shands courts. And as I was arguing earlier, parties don't make proposal for settlement decisions based on some notion of the exact amount of costs or prejudgment interest on the day of the offer. They consider a mix of factors or assessments of liability, how much a plaintiff would accept, how much the defendant's willing to pay, what they think the bottom line is going to be at the end of the case.
Counsel, can you sum up now? You're over time.
Yes, so we're asking the court to apply the proposal for settlement judgment statute according to its plain meaning. That includes all costs and all prejudgment interest. Costs because they're part of the judgment, prejudgment interest because it's simply an element of pecuniary damages, There's no basis in the statute to distinguish between pre and post offer amounts of those components of the net judgment entered. That was never intended by White or Shands. So the court should clarify that any suggestion in those cases that you only look at pre-offer amounts was dicta, or alternatively recede from that suggestion because it's contrary to the clear and plain meaning of the statute. And
All right.
we ask,
Thank you. We thank you both for your arguments in this case, and the court will now stand in recess for about 10 minutes before we take up the next case on our docket. Thank you.